Welcome to Didactic. I am Dr. O'Leary, a fourth-year psychiatry resident in the National Capital Region. Today is March 2nd, 2024. This is a podcast about psychiatry and neuroscience, and I produce it in my free time. While I try to be as correct and informed as possible, I really don't have the staff to double-check my facts or point out my errors or even point me in the right direction. If you, the listener, want to make a comment, you can go to scidactic.com and fill out a form at the bottom of the page there. You can also go to YouTube and type @scidactic into the search bar and use the comment feature there. When available, I post my transcripts and references for each episode at scidactic.buzzsprout.com. Everything I say here is my own opinion, even if I quote someone else. That is just my opinion about their opinion. I do not speak for anyone else, including the Department of Defense, the Defense Health Agency, the U.S. Army, or the Supreme Court of the United States. I say that because today I am going to discuss a Supreme Court ruling that limited legislatures from requiring minimum sentences of life in prison without parole for minors. The decision itself, I think, is less interesting than some of the reasons that the decision was made. Many of these were technical legal points. However, developmental biology also had something to contribute to the decision. In 2012, the Supreme Court heard two related cases involving adolescents convicted of murder and sentenced to life in prison without parole because of mandatory minimum sentencing guidelines in place in their states. One of the boys, Evan Miller, along with an accomplice, had beat a man unconscious with a baseball bat after a fight that had ensued when the man awoke, finding Miller robbing him. Miller and his friend then decided to set fire to the home to cover up the evidence. This resulted in the man's death. The second petitioner, Kuntrell Jackson, had accompanied two other boys to a convenience store in order to rob it. During the robbery, one of the boys, not Jackson, shot and killed the clerk. Both boys were convicted and were sentenced according to minimum sentencing guidelines to life in prison without parole. The decision that the court was asked to make was not whether the boys should have been convicted, but instead whether the sentencing guidelines that resulted in them being given life without parole constituted cruel and unusual punishment under the Eighth Amendment. Let me start with some background on the judicial branch. The courts make decisions based on their interpretations of the law, which is presumed to be based not only on their understanding of the letter of the law, but also on the intent of the lawmakers. Laws can be in conflict with each other or in conflict with the Constitution, which constrains the law. Courts get to decide if laws are valid or if the enforcement of the law is within the power of those who executed that power. Courts are not like religious or scientific associations. When they decide on laws, they're not deciding whether the law is morally right or scientifically and empirically defensible. They're deciding whether or not those that passed or enforced the law had the authority to make or enforce that particular law, regardless of its content. A law can be entirely absurd, such as like requiring citizens pay higher taxes on Tuesday than on Friday. If a law like this is challenged in the courts will not decide whether the law appears arbitrary or not. They're merely deciding whether or not it meets the standards that laws have to meet in order to be laws or to be enforced. Sometimes there's no consensus as to the constitutionality of a law, and in these cases, courts have to consider more than just the opinion of one justice or judge as to whether or not they like the law. but on arguments from petitioners as to whether the law passes particular tests. Some of these tests include things like whether the law is too vague. If a law is such that it is frequently read and enforced differently across different jurisdictions, then it could be nullified and effectively sent back to the legislature for clarification. But that's pretty rare. More often, laws are judged based on whether the court's understanding of the Constitution permits such a law. To determine how a law should be interpreted or how the Constitution should be interpreted, the courts rely primarily on evidence concerning things like the letter of the Constitution, but also the intent of the legislatures, and also, importantly, other court rulings. If there are documents outlining the reasons that legislatures passed a law, then the courts can be guided by the spirit of the law. If the law has been consistently interpreted by courts in the past, then that is strong evidence for or against a current interpretation, and that the law is easily interpretable. Another consideration, though, is the common law. The common law is basically things that haven't necessarily been written down by lawmaking bodies, but have been assumed by courts for a very long time. In this case, laws kind of become laws because they always have been laws. Also, how you interpret the law can be a part of common law. How you interpret the language in the law can be part of the common law. Sometimes judges just have to make decisions because no one else has. Public opinion might also be used as a means to interpret the law and whether or not it's constitutional. For example, what constitutes cruel and unusual punishment? The definition of this has certainly changed over time as society's appetite for retribution has evolved. There are judges and justices that give far more weight to legislative intent than they do to public opinion, assuming, among other things, that if the public wanted a different interpretation of the law, they would have elected legislatures to change that law. So, public opinion is reflected in the legislature. There are also others who are more likely to approach the concepts inherent in laws as malleable or changeable, so that every time society kind of shifts in its understanding of vague concepts like cruel and unusual, we don't have to completely rewrite all of our laws to clarify that or change our constitution to incorporate different, more modern language. The concept of shifting public understanding is where arguments about things like ethics, morality, and science can most easily find their way into a courtroom, even though these aren't the things that the court primarily decides on. Today, I'm going to focus on how courts have most recently interpreted the capacity of adolescents and children to be able to consider alternatives, understand the consequences of their actions, make informed decisions, and control their behavior under normal and more stressful circumstances. In 2012, when the Supreme Court decided the case Miller versus Alabama that I mentioned earlier with the two minors that had committed murder and were sentenced to mandatory life in prison, it was a divided opinion. 5 out of 9 justices determined that minors cannot be subject to mandatory life sentences without the possibility of parole, even if they're convicted of something like murder. It had previously been ruled that minors could not be subjected to the death penalty because of the Eighth Amendment. I do want to point out here, so that I don't confuse the listener, that the court did not rule that adolescents could not receive a life sentence. They ruled only that it couldn't be mandatory. Sentencing bodies must at least consider lesser sentences. Now, the logic for this ruling did not rest primarily on the Constitution alone because it's a little vague what cruel and unusual or excessive punishment means, and it also didn't rest primarily on things like the science of brain development. The arguments really were around what is cruel and unusual, but science potentially could inform that. Another thing that could inform that is a legal principle called proportionality. How bad was the crime? I mean, like if you give a death sentence for speeding, obviously that lacks proportionality. But what about a death sentence for speeding that resulted in the death of a pedestrian? In Miller v. Alabama, the proportionality of the sentence wasn't a huge issue. A bigger issue was really the culpability of the accused. Are there mitigating factors that should be considered before a sentence is rendered to a minor? Now, this is where developmental science gets a chance to actually give an opinion. But the courts also have to consider former decisions of courts, decisions that have limited, for example, the death penalty in youth. And what were the reasons that the courts did that? They also gave a large amount of weight to considerations about what was the intent of the legislatures that passed mandatory sentencing laws. Did they even consider minors when they did? Additionally, the court thought about public opinion. What does the public think about sentencing someone who committed a crime as a minor to a life in prison? In Miller v. Alabama, the justices disagreed sharply on whether one could assume legislatures had or had not considered adolescents when they made mandatory sentencing laws that did not distinguish between youth and adults. And it was very hard to figure out, well, what does the public think about this? Because there's really no good data for that. But there did seem to be a consensus that the younger a person is, the less they should be held to the same standards as adults. But it's obviously difficult and maybe impossible for them to draw like an arbitrary line at an arbitrary age. I mean, other than like 18, because, well, that age has a long legal tradition of having arbitrary lines drawn there. Also, how much mitigation should the mere fact of age play in a decision to sentencing life in prison or not, as opposed to the death penalty? Is reducing a sentence also reducing deterrence to committing crimes as an adolescent? If they know they might not get life in prison, would more adolescents commit a crime? If adolescents are less culpable than adults, then why not just excuse the crime altogether? I mean, or find them not guilty by reason of adolescence. The petitioners and the justices have to throw around a lot of assumptions. One of those assumptions is that youth have a higher chance of rehabilitation than adults do. But do they? This has been an assumption used in the past in courts. Questions like this are where science can make some difference in the opinion of the justices. In fact, in the opinion of the Supreme Court in Miller v. Alabama, Justice Kagan referred to a 2003 paper in American Psychologist titled Less Guilty by Reason of Adolescence, which I'm going to use extensively while putting together the rest of this episode. One of the first mitigating factors considered is that adolescents are less rigid or predictable in their thinking than adults, and consequently, they're more likely to be influenced by other humans, like adults or their peers, or the circumstances that they're in. What might be taken like as an order that could be easily dismissed or disobeyed by an adult might be far more coercive to an adolescent. An action committed by a minor is then assumed to be less predictive of future actions because it's less likely to be internally motivated. Another way to put it that maybe judges would understand is that an adolescent's character is not as specifically attached to their actions. Psychiatrists understand what the legal people call character more as personality, both of which become more and more rigid as someone ages. With regard to sentencing, courts have a long history of giving people who they deem are of poor character more severe sentences because they seem less redeemable and a higher risk to society. Even if someone were to assume that an adolescent has the same ability to reason as an adult, like that their basic capacity for reason is the same as adults, it's almost certain that they have less information and less experience to draw on when making that decision, and that could reflect in the quality of those decisions. Even with the same capacity for reason, they lack the substrate needed to make informed decisions. And this can be a double edged sword legally for adolescents because arguing this could not only reduce the culpability of the minor for a crime or maybe reduce their sentence, but it could also limit their ability to autonomously make decisions about things that affect them. For example, things like contraception, sexual consent, getting an abortion. We could also limit the autonomy of minors to enter into legal contracts for a similar reason. Another consideration is not the lack of information and experience, but the presence of biased information, of misinformation, or of adverse experiences, which could further complicate whether or not someone is even able to make the kind of decision that would have prevented a crime from being committed under the circumstances. The thing I find most fascinating about this line of reasoning is that it's not actually confined to minors. I mean, many adults grew up in unpredictable, deceitful, irrational, chaotic, abusive, or neglectful environments. Should this be a mitigating factor for adults as well? If so, this could preclude mandatory life sentences without parole for really everyone. Following Justice Kagan's arguments, which rested at least in part on the fact that adolescents had no control of their developmental environment, I feel like this could be extended to adults in the future if this line of reasoning is continued in the courts. Will lawyers start to say that a sentence of death or mandatory life without parole for an adult who could demonstrate that their childhood was severely adverse is cruel and unusual? I mean, that's speculative on my part. And today I'm talking about adolescence, so let's get back to adolescence. Adolescents are not only more influenced by authority figures, but also by their peers. The opinion of their peers exact a large influence over them. This might be related to the lesser developed ability of adolescents to maybe accurately calculate risk and their need to please their peers to be accepted. I mean, humans in general have very poor risk estimating abilities, but it's really far worse in adolescence. And a poor ability to estimate risk or benefit is a hazard that can become extremely important in certain circumstances, especially highly stressful ones, and when there's also very little time to consider alternatives. Other factors could predispose adolescents to coercion or poor decisions, like a relative lack of consideration for the future or enslavement of their thoughts to their current emotional state. I think of the young man who has a girlfriend of 3 weeks and then she breaks up with him, and it feels like the end of the world. He may never love again. I mean, this tendency toward absurd overvaluation of the present in adolescence is even famously illustrated in Shakespeare's Romeo and Juliet. I want now to mention another paper. This one was in Psychiatry, Psychology, and the Law in 2023, so it's a lot more recent. And it broached the same subject that I'm talking about today. It was titled Old Enough to Offend but Not to Buy a Hamster: The Argument for Raising the Minimum Age of Criminal Responsibility. It was written in response to the fact that the age of criminal responsibility in Australia and England, according to the author, is set at 10 years. Their legal precedents are different than in the United States, and I don't think the United States actually has a minimum age. But the author, Yulish Singh, begins arguments by stating that since the 14th century, the courts in England have recognized that criminal defendants were afforded the right to meaningfully participate in their defense because, quote, anything less would render the right to a trial empty, unquote. The ability to participate now is called capacity to understand proceedings. Singh characterizes as, quote, ludicrous the fact that, for example, in Australia, 10-year-olds are banned from owning hamsters out of fear that they could not possibly care for them, but at the same time, they're expected to be able to stand trial. Singh reports that from the 1800s to about the 1960s, children in England, the US, and Australia were subjected to more of a welfare model of justice in which they had really little autonomy to affect the outcomes of their life. But they were also thought as less culpable for the errors they committed and more amenable to rehabilitation. In the 1960s, though, advocates for more due process for youth and less paternalistic state involvement helped to change the system into one that visualized justice not as what was best for the child, but as what was best for society. Singh asserts that society traded in a focus on rehabilitation, where children were seen as something that needed to be repaired, to a due process model of justice, where children became a focus of retribution, similar to how adults were treated. Singh points out that sentences were steadily made more severe, and barriers to moving a defendant from the youth system to the adult system were reduced. Now, being published in 2023, this paper refers to knowledge subsequently gained in the 11 years since the Miller v. Alabama decision and about 20 years since that 2003 paper quoted by Justice Kagan. And it especially highlights neuroscience advances. For example, it had been demonstrated that during adolescence, there are rapid changes in the limbic system and our executive networks. Singh refers to these as the socio-emotional system and the cognitive control system. There are many other names. The socio-emotional system, according to Singh, develops more rapidly, and these developments include greater dopamine delivery to the limbic system, resulting in more reward and novelty seeking, which can be manifested as impulsive or risky behaviors. There is no such thing as reward without risk, and adolescents tend to prioritize reward over risk, especially hypothetical risks or unexperienced risks or unknown risks, if they even consider risk at all. The cognitive control system, according to Singh, in the prefrontal cortex, also gets more dopamine, but this system develops more slowly. You could say that it's kind of constantly playing catch up with the limbic system. It makes sense that our ability to plan and predict outcomes would come only after more novel experiences have already happened, many of which were far more risky than our parents would be comfortable with, especially those that were instigated by social pressure from our peers. There's also, of course, all those pesky hormones, right? Like testosterone and estradiol, oxytocin and vasopressin. I mean, these, among many other things, influence how we establish social connections and view hierarchies and how we develop our values. Testosterone in particular is famous for inspiring us to move more aggressively toward our goals. Additionally, there's accelerated synaptic pruning during adolescence. Brain signals are also progressively sent faster as myelin is laid down on our remaining axons. Even though a lot of these processes are generally mostly complete by age 16, and 16-year-olds can generally think as fast and efficiently as adults, they still have substantially less experience to draw on, and their frontal lobes actually continue to develop higher reasoning abilities even into their mid-30s. You could say a 16-year-old is like a computer right out of the box. In order to become truly functional, you really have to load a lot more software onto it and plug other things into it. And this is my metaphor, not Singh's metaphor. Given that our executive centers are programmed by our experiences like childhood neglect, abuse, maltreatment, or merely having to survive in an unpredictable environment can have dramatic effects on how our limbic system identifies and responds to possible rewards or threats, and how our cognitive centers develop ways to adapt our behaviors. The word we use for behaviors that develop in neglectful or abusive or unpredictable environments is maladaptive. If a child is used to experiencing lose-lose situations, then the strategies developed to cope with this kind of world might involve things like defiance, avoidance, deceit, or the lack of ability to be able to predict more than kind of superficially the emotional states, desires, or wants of other people. The brain might stop trying to play a game that it can't win and just kind of give up. Or it might develop rules that seem illogical to us as people who didn't grow up in those environments, because the people who did are responding to a game that the most of the rest of society has never had to play. Most recently, our society has been moving toward less culpability for youth, with younger age predicting less accountability. Historically, this pendulum has swung back and forth on this issue. For example, before the 1800s, children were frequently executed or punished similarly to the way adults were. At least in Australia and England, a more paternalistic approach replaced that, and youth started to be treated as kind of highly malleable and reformable, but also needy of state intervention. The state necessarily exerted a large degree of control over their future and prevented them from making their own decisions. And then in the late 20th century, ideas shifted toward more autonomy and rights for youth to choose for themselves, but this also resulted in greater culpability for crimes. In the 1980s and 90s in the US, when legislatures began to pass more minimum sentencing guidelines, youth as well as adults were subjected more frequently to sentences that may not have been imposed on them in the past. Now it appears that that pendulum might be swinging in the opposite direction again. However, in the Supreme Court, the decision to disallow mandatory life without parole sentencing for minors passed by a mere 5-4 majority, which indicates that there is still disagreement as to whether severe punishments without considering the exigencies of youth are in fact cruel and unusual. Thank you for listening. I am Dr. O'Leary, and this has been an episode of Psydactic.